Good morning. All right, well, good morning, everyone. Officially call this meeting to order. We're looking forward to a good conversation and some good testimony. We'll start at Representative Boyd. Any opening remarks?
Good morning to everybody, and we look forward to some good discussion. So thank you, Senator.
Of course. Senator Ciccariello, any opening remarks?
No, just looking forward to hearing the testimony and looking forward to a good meeting.
Fantastic. I don't see Representative Vale here yet, so we'll get started with Commissioner Sadi, who's been gracious to wait a few minutes. Thank you, Commissioner, for your patience, and we look forward to your testimony.
Thank you very much, Senator. Senator Cabrera, Representative Boyd, Senator Ciccariello, honorable members of the Veterans Affairs Committee. I'm Thomas J. Sadi. I have the pleasure of serving, the honor of serving as Commissioner of Veterans Affairs for the state of Connecticut. I thank you for the opportunity to address you, and also thank you for your service to our state, in particular to our veterans and service members. My testimony today will support on those bills related to or impacting Department of Veterans Affairs operations and or those concepts the agency has supported or worked with legislators in the past on, beginning with House Bill 5367, an act concerning special registration marker plates for motor vehicles, certain veterans and members of the armed forces. Public Act 21-106 established for the first time in Connecticut war/conflict-specific motor vehicle license plates for Connecticut veterans. And in doing so, cross-referenced state statute, which then cross-references federal law related to specific conflicts to be included on these plates. However, while the Department of Defense, federal VA, state VA, and other agencies all recognize the conflicts or wars in Iraq and Afghanistan, these are not specified in the referenced state statutes or federal laws. So what this bill does is simply codifies those conflicts as previously recommended and currently administratively included, Iraq and Afghanistan veteran marker plates, into the statutory system. I would recommend, though, something slightly different than what the bill proposes. To add these conflicts into the existing list of periods of war in Section 27103A of the general statutes, rather than embedding them in the Motor Vehicle Title 14 statute. My written testimony provides more detailed information as to the language and the reasons for doing so. With regard to House Joint Resolution 92, I absolutely, and the department supports the recognition of Chief Harold Taquinjian of the Mohegan tribe for his patriotic service to the United States, both in the Coast Guard and in combat in World War II, and in particular, the service recognition he received for saving not only himself, but members of his flight crew when they were shot down by the Japanese on the island of New Guinea and survived for 23 days until being rescued. With regard to Senate Bill 345, exempting veterans from payment of fares for public transportation services. This bill proposes to waive those fees for public transportation, and while the department defers to the Department of Transportation as to the fiscal impact and the logistics of implementation, the DVA, the Department of Veterans Affairs, supports the concept. I do add one caution that there are veterans who do not have the veteran indicator on their driver's license, non-driver's license ID, and that it would be very important to educate the veteran community and the DOT, if this bill passes, that it is a government state-issued identification card or license that will be required. Many veterans carry service organization cards or VA healthcare cards. I certainly support that a state ID is the one that is being used, particularly because veteran organizations have different standards of membership and oftentimes include auxiliaries and sons of or daughters of divisions that do not comport with the veteran eligibility requirements in 27103. And there's more information in my testimony regarding that. With regard to Senate Bill 339, technical revisions to the statutes related to veterans and military affairs, the department supports this bill. These technical revisions just clarify some grammatical issues and title updates. There is no substantive impact on the delivery of services. It just makes it a cleaner statute or statutory section. I'm going to get a little more detail with the next bill. Senate Bill 340, an act concerning applications submitted to the Department of Veterans Affairs Qualifying Review Board. What this bill would do is formally would formalize an administrative procedure whereby veterans who obtain under existing law a clinical determination that either PTSD, TBI, or military sexual trauma was more likely than not primary reason for an other than honorable character of discharge. They may then submit that clinical determination now under this bill to the qualifying review board so that the board can then issue them a standard restoration of Connecticut State Veteran Benefits decision letter. This decision letter does not reference the veteran's underlying medical condition or circumstances under which the restoration of eligibility was based, except to state that the veteran is now eligible for state and municipal veterans benefits. The bill also addresses the fact that the qualifying review board is not equipped to conduct clinical reviews, and instead they can now rely on the existing clinical determination process to support the board restoration of veteran state benefits. I provided a much more detailed explanation as to the process and procedure in my written testimony, and strongly encourage the passage of this bill, again, allowing a more detailed but more smooth process for those who have either the 3 initial qualifying conditions or those individuals who received an OTH based on sexual orientation, gender identity, or expression to be able to have restoration of their state veterans benefits. Senate Bill 341 is an act concerning property tax relief for veterans and armed forces. Veterans and members of the armed forces. The department supports the establishment of this task force to study such property tax exemptions, abatements, and similar benefits. And my testimony includes more detailed information regarding this review related to testimony I provided in previous years supporting this effort. Now, Senate Bill 338 is an act concerning the study of municipal veteran services. And just prior to this meeting, I made a mention to Senator Ciccarella that my testimony may not be as smooth as some people may think from the standpoint of the support for this bill. Not smooth, but in line. I absolutely, and the department appreciates the good intentions behind this bill, as we certainly recognize that periodic updates to programs can improve delivery of benefits. Oh, sorry, someone opened the microphone. I'm getting a feedback echo. Okay. The Municipal Veterans Representative Program was established nearly a decade ago, and through the efforts of the Department of Veterans Affairs has been updated several times working with legislators at the VA committee, including the addition of mandatory training and reporting requirements. The department has, without any additional staff or additional funding, provided the required annual training, certificates of completion, supplemental training materials, and conducts an annual survey of all 169 municipalities to collect updated contact information regarding each of the municipal veterans representatives, commissions, or boards under the statute. However, the department does not have the staff or the funds to hire additional staff to implement the provisions of the bill to conduct such an intensive review and study of resources, time, fiscal records, technology, and staffing of every municipality, then to compare all those municipalities to each other, and then to report recommendations with regard to that analysis. This would be a highly involved project requiring at least the addition of a full-time analyst to the DVA staff, as well as a full-time administrative support position and the related salary appropriation. However, because this is a limited time project, it may make more sense, if you proceed with this, to hire or to delegate hiring of a consulting firm in order to conduct this review. Instead of either of these, what I recommend the committee consider is that members of the committee meet with myself, DVA staff, Veteran Service Organization leaders to discuss concerns with the program and to develop ideas to improve the program based on existing DVA and Veteran Service Organization and your knowledge and concerns, obviating or alleviating the need for additional expenditures, additional staff, and waiting for a year to complete a study. But instead, let us utilize the information experience I think that many of us already have. I certainly have recommendations that I can provide to the committee. I have 2 more bills, and I'll move as quickly as I can here. Senate Bill 342 is an act concerning federal reimbursement for pharmaceutical purchases. This bill relates to the federal reimbursement program for pharmaceutical purchases made by the department with funds from our institutional general welfare fund. And we utilize a federal formulary pursuant to an MOU with the federal VA. While the change in law that this bill would effectuate was previously needed, Special Act 2115, the biennial budget bill, provided the funds allowing the DVA to purchase these pharmaceuticals with appropriated dollars rather than IGW dollars last year. And this year, the governor's proposed budget adjustments again provide the DVA with the needed funding to cover these costs for purchasing pharmaceuticals and for fiscal year 2023 and going forward, thereby alleviating the need for the proposed legislation to deposit the reimbursement in the IGW. The reimbursement can now still go to the general fund because we are receiving the additional dollars from the general fund to make those purchases. The final bill is Senate Bill 344, an act concerning state contracting price preferences for veteran-owned businesses. The department was supportive, and under former Commissioner Conley and myself working as his legislative liaison, we pushed for this several years ago initially. It makes some minor technical adjustments to clean up the statute a little bit, but I would recommend one possible change. Currently, the statute reads that an eligible veteran-owned micro business for the state veteran bidding preference must be 51% or more owned by a veteran. This has created a problem that I've seen in many applications to our agency for certification of eligibility for this bidding preference. Inasmuch as we have a husband and wife, siblings, or business partners, or a parent and a child who are equal partners in the business, one of whom is a veteran, thereby making the business only 50% owned by the veteran, precluding them from being eligible for this bidding preference. I would recommend that to be a veteran-owned micro business eligible for the bidding preference, that the business must be at least 50% owned versus 51% owned by a veteran. I thank you for your time, for your service to our veterans, and I'm happy to answer any questions committee members may have. Thank you.
Thank you, Commissioner Sadi, for your testimony. We appreciate your time. I see Senator Olson has her hand up. Please proceed, Senator.
Thank you very much. And I'm in my car, so I'm not going to put my video on. And I hope I don't hit the 2 or 3 dead zones on Route 2. I just have one question, Commissioner, relative to tax abatements and tax credits. The current base tax credit for veterans, if you're a veteran, doesn't seem to really give much real value any longer. And one of the bills, and I'm not certain if it's on today's committee meeting or another one that's coming up, is to have in previous conversations with you, indicated that we should review all tax abatements and tax credits for veterans to see where we are. You just indicated in one of the other bills that you would have a hard time without the appropriate staff. Is there any way for the VA to participate in such a study to make sure that we're having tax credits and tax abatements and any sort of relief on taxes for veterans relevant in the intent that it was originally designed for, or would you need more staff? Thank you.
Senator, thank you for the question. And I absolutely support the task force, which was something that I recommended last year when the agency was going to be tasked itself with conducting the study and making recommendations. For that, I would have needed additional staff and or external experts. With the task force approach, the agency can absolutely provide input and information, but the task force is a much larger entity. I presume that the task force will also have staffing assigned to it and can call experts before the task force to provide information, including individuals potentially from OLR, LCO, OFA, who may be able to provide specific data, as well as call members of the Connecticut Conference of Municipalities and from the Assessors Association of Connecticut before it to provide information. Taking that approach through the task force, I believe, is the appropriate way to make a uniform and full spectrum review of these abatements and exemptions. And as you said, very, very accurately, Many of these have not been adjusted in decades, not taking into consideration significant changes in values of homes, mill rates, and approach to municipal property taxation administration. Thank you.
Thank you, Commissioner. Senator Olson, your hand is still up. Do you have another question?
Yep.
Yeah.
No, I'm all set. Thank you.
Okay, thank you, Senator. Any other questions for the Commissioner? Seeing none. Commissioner, thank you for your time this morning and your testimony. We appreciate it.
Thank you.
Okay. Up next, we have Major General Francis Yvonne. General.
Hey, good morning.
Good morning. Morning, sir.
Good morning, Senator Cabrera, Representative Boyd, ranking members, Senator Ciccarella and Representative Vale, and members of our esteemed Veterans Committee. As most of you know, I'm Major General Fran Yvonne. I'm honored to serve as the Commissioner and the Adjutant General of the Military Department and the Connecticut National Guard. And I thank you for the opportunity to testify today and request a favorable vote on 3 of the Military Department bills that are on the agenda. They are an act authorizing the issuance of a military funeral honors ribbon, an act concerning the composition and organizational structure of the Governor's Guard, and an act concerning monies for state military morale, welfare, and recreational programs, what we call MWR. I've submitted detailed written testimony concerning these bills and will touch on each briefly. But before I do, I wanted to provide a quick update on the state of your military department, the Connecticut National Guard. Your Guard has experienced an extraordinary and again, unprecedented year in terms of both domestic and overseas deployments. Over 1,000 members of our organization and the Governor's Guard, the militia, have supported their own communities in the state since the beginning of COVID and the start of the pandemic, from managing medical equipment logistics to vaccinating Connecticut residents. We've answered the call to duty. And even as we sit here today, we've got roughly 300 that are still serving as we close out the COVID support efforts and end of mission on March 15th. We are also managing what most folks don't know under the dual status commander. We've established that those 3 active duty Air Force teams are also under the direct command and control of Brigadier General Ralph Hedenberg, who's the dual status commander. Additionally, in addition to COVID, the Connecticut National Guard has deployed over 1,000 soldiers and airmen around the globe over the past year, its greatest number in over a decade. Our soldiers and airmen served admirably in the Horn of Africa, Kenya, Jordan, Qatar, Kosovo, and Spain, and continue to do so today in Poland and Kuwait. So you can rest assured that when needed, Connecticut's home team will always be ready and always there. As I turn to the bills on today's agenda, I'd first like to discuss an act establishing a military honors ribbon. The bill authorizes a service ribbon to recognize members of the National Guard, organized militia, and veteran service organizations who perform honor guard details at funerals of deceased veterans. As required by law, the department performs this duty at over 3,000 funerals each year. This act provides a modest means to recognize those who perform this solemn duty, and the purchase of the ribbons will be made available at a modest cost through the current agency appropriations. As I sit here waiting to get on today, I've got an email from a family of a funeral of a deceased Korean War veteran, a funeral that we did last Monday, and just a total honor, especially when you think about family members who didn't know much about the service members' service, and it's really a fitting honor as we later rest those who served their great nation and our state. Next, an act concerning certain conforming statutory changes related to the Governor's Guard. This bill updates century-old technical language regarding the composition of the Governor's Guard. It's forward-looking. It provides the units and the department flexibility to change the unit's composition as their mission and membership may change, but it doesn't require any immediate changes. It removes the cap on the number of members and ensures they receive all the privileges and immunities of law when performing military duty. Simply, it empowers the unit, it empowers their chain of command, and it brings the statute up to date. And finally, Senate Bill 348, an act concerning the military department's morale, welfare, and recreation account. Like I said, MWR. This bill expands the utility of the account. The act allows for the use by all members of the armed forces of the state, not just the Connecticut Army National Guard as it's currently written. It permits the department to accept donations from outside sources for the benefit of members. And generally, this account is used to fund unofficial events for which no federal or state appropriations are received, like the Armed Forces Day Luncheon, many of our deployment and welcome home ceremonies and unit picnics. It's simply meant to enhance the quality of life for our members and their families. So thank you again for the time and consideration and support throughout. And I remain ready and to answer any questions as needed. Thank you again.
Thank you. Thank you very much for your testimony today, sir. We really appreciate it. Any questions? Representative Boyd?
Thank you, Senator. General, I just wanted to thank you and the team for the work that you've done over the last couple of years. Everybody on the committee is very thankful that we have such a talented group here in the state to be able to react to all kind of stuff as well. So the committee thanks the Guard for everything that you've done in your leadership over them. The only question I have, and I appreciate your detailed testimony and the work of your legislative team, is we've also have pending before the committee a proposal to increase the pay for those that serve in the honor guards, and I didn't know if you or the department had any opinion on that bill.
Yeah, so bottom line, it comes down to dollars and cents. So if we can get it into the budget, and OPM can work it in, I think it would be a great initiative that's well deserved for those members. So many times, quite honestly, and the source of some of the testimony you may see is that members of veteran service organizations actually do 3 funerals a day and they get paid for 1. So I'll leave it at that. But
Right.
definitely, thank you.
Thank you. Appreciate it. Thank you, Senator.
Thank you, Representative. Any other questions? Seeing none, thank you, sir, for your service and for your testimony today. We appreciate it.
I appreciate the time and thanks for all your support.
Of course. All right, up next, I don't know if Manuel Meneses is here from Representative Corpus office. I don't see him here. So we'll move on to, is Patricia Erickson on the call? Do not see her either. Brian Burbidge. Oh, I see Patricia. Is that Patricia? Patricia Erickson, are you on?
Excuse me, Senator.
Yes.
I just wanted to make sure that the attendees who want to speak know that when they are upgraded to panelists, they have to accept the invitation in order to become panelists and be able to speak. So there are several people who have been invited to be panelists who haven't clicked on that yet. So they should be coming up into the room.
Okay, I'll wait a moment. Thank you. All right. I see Mr. Meneses. Great. Is Manuel Meneses here?
Yep, I'm here.
Hi, Mr. Meneses.
So-
How are you today?
Hey, how you doing there, Rep Boyd? So I wanted just to partake as an attendee. I didn't realize I registered to testify during the day, but I did want to bring up a couple points. I know we try to stay on our swim lane here in the federal side. For those that don't know me, I'm Manny Meneses. I'm the Veterans Representative for Congressman Courtney in the 2nd Congressional District. I just wanted to make a couple points here in Connecticut. I receive a lot of phone calls, and the reason I wanted to partake in this meeting was for the Veterans Committee itself. A lot of the phone calls we receive with regards to property tax exemptions, get a lot of phone calls from veterans who served. And for your consideration, maybe changing the the law that allows all veterans to receive a small exemption regardless of their wartime service or not. That being said, there's also, I brought it up to a few senators with regards to licensing with regards to hunting and fishing. We're only a handful of states, maybe 3 in the entire nation, that doesn't give a discount or does not charge veterans to go fishing in our state. You can look that up. It's pretty embarrassing if you look at it, and I don't think we just don't realize it. And the last thing was aid and attendance. For those that are familiar with any wartime veteran, service member, and or surviving spouse, or even if the spouse is alive, can receive aid and attendance to assist them in paying and offsetting the cost of, say, assisted living. And we are also a handful of states that includes that as income when, requesting assistance from the state of Connecticut with regards to Medicaid. So I just want to point out those details to everyone in this committee, so they realize that. Other than that, that's all I really wanted to talk about. And thank you for giving me the time to speak. Appreciate it.
Sure. Thank you so much for joining us. Any questions for Mr. Meneses? All right, seeing none. Thank you, sir, for your time and testimony today.
Thank you.
Up next, I see Ms. Patricia Erickson. Hi, Ms. Erickson. How are you? Please proceed. I think you're on mute. You're on mute.
Okay, can you hear me now, sir?
There you go. Yep, you got it. We can hear.
I apologize. This is my first time for joining into a session, even though I've been active politically for 30 years.
That's okay. You're doing great.
I contacted my state rep, Bill Buckby, after finding out that we have 2 conflicting state statutes regarding 100% disabled veterans. My brother is 100% disabled, very low income, but because they considered his disability from the VA as income, he was not able to get the lower income help for being a veteran. He came home from Vietnam and he's never been able to hold a job since. He is got 100% PTSD and a traumatic brain injury. It's affecting him, and I'm sure many other 100% disabled veterans. The issue on the table is one of the bills or one of the statutes says that the disability is considered income. The other one says it's not. The IRS does not consider it income. So if the IRS doesn't, that's pretty bad. I mean, they tax us on everything, including the air we breathe. So I'm hoping that I talked to the Office of Policy and Management, and they said they just need to delete one of the state statutes that conflicts with the other so that they do not charge these veterans that have come home completely disabled from serving our country and hold it against them when they need benefits. And I believe if it's possible, my retired commander husband would like to speak on the issue, and he's sitting next to me. Is that okay?
Yeah, that's fine. It's how much time? Just a few minutes we have. I'll let him do that quickly.
Yeah, it'll be real fast, sir.
Okay.
Good morning. This is Commander Michael Erickson, United States Navy retired.
Good morning, Commander.
I appreciate your time on this issue. Watching my fellow veterans lose out on benefits because their disability income is considered taxable income, where it is not. These guys do not receive a 1099 annually. It's just they get a one-time letter that states that they've received the benefit, and that's it. But thank you for your time. I appreciate your efforts, sir.
Thank you, sir. Thank you for your service to our country, and thank you so much for taking the time to talk to us today. Any questions for Ms. Erickson? Seeing none, thank you so much for your testimony today and your time.
Thank you very much.
Thank you. All right, up next, I see Representative Connolly is here. Representative, good morning.
Good morning, Senator. I appreciate Senator Cabrera, Representative Boyd, and the other members of the committee giving me an opportunity to speak about HB 5373, an act about concurrent jurisdiction for youth crimes on federal military installations. We have 2 federal military installations in southeastern Connecticut, the New London Navy Base, which is located in Groton, and the Coast Guard Academy. And it's been brought to our attention by the Department of Defense that when a juvenile commits a crime, that their only opportunity to charge is under the federal statutes, and that is adult crimes with fines and jail time. There is no juvenile relief. So think of a youth who might be upset that their parent is off in a dangerous war zone right now, might throw like a brick through a window, shouldn't do it, but still more of a minor crime. That youth under the federal law would be charged with a fine up to $100,000 and up to a year in jail. Whereas if we had concurrent jurisdiction, that youth could go to the JRB in Groton or New London, get some counseling, get some anger management, maybe do a community project and realize they're not alone with their thoughts about their parent being off in war, and leave with no, get help and not have a criminal record. So by allowing this concurrent jurisdiction gives the military options for these minor youth crimes, noting that we have more youths who are under stress due to COVID and war zones that have recently developed. And this would just give a lot more tools in the toolbox to make sure that our youth don't have records, get appropriate punishments, and really help out the young people of New London County.
Thank you so much, Representative. Questions, Representative Boyd?
Thank you, Senator. Good morning, Representative. Thanks for joining us.
Good morning,
So my question is around kind of what the practical piece of this looks like. And I know we have a representative from the Department of Defense later on, but the main responding authority right now is federal, right? I would assume military police or the NCIS or something to that effect. Who would then make that determination as to the path that it goes? And is that an area that needs to get worked out, or is there an MOU then that would take place to determine what the actual process is as to which path any type of criminal enforcement might go?
Yeah. So we, the military police or NCIS, work well with state police and our local police because, as you can guess, crimes cross, people cross, and they already have that relationship. But what would happen is currently, if it's a minor crime, the choice is either this very high penalty with jail time or no charges at all. And a lot of times the choice is no charges at all, which includes no mental health counseling, no referrals to appropriate state services that we have right here for these youths. And so this would allow someone to realize, hey, we've got a youth, they need services. They can transfer them over to the state system if the military feels it's a minor issue that should go to the state circumstance. But if the military feels it's a major issue, like lighting, in Maine, someone lit fire to a submarine costing billions of dollars, they clearly would not send that out of the federal system. They'd keep that in the federal system. So the military has the authority to decide it's a state system, it's a minor crime. Let's avail this juvenile resources in our state. And then it would get transferred over to the state system.
Thank you. You may not know this piece, but does, or would this enable, for example, like DCF to have authority, or do they now? Kind of what because that's kind of hand in hand, perhaps, with some of these issues.
DCF is involved with children who live in the military base if needed.
Okay. Presently,
yes.
All right. Awesome. All right. Thank you very much. Thank you, Senator.
Thank you, Representative. Any other questions, Representative Conley? Seeing none, thank you, Representative, for your time and your testimony today.
Thank you.
Have a good day. All right, up next, we have Mr. Brian Burridge. Burridge, are you there? Thought I saw you. Yep, I see you. You're in the room. You just have to unmute your camera on.
Okay. I am.
Good morning.
Good morning. Good morning. I don't know if you can see me. Okay, there we are.
There we go.
Okay, good morning. I am the East Lyme Veterans Representative. I act as a hall monitor when veterans call me about their benefits and how to get through the VA system. My biggest complaint is the information is not getting to the veterans. I am the East Lyme Veterans Coffee House Coordinator, and I find the coffee houses are the best way for veterans getting together, talking about veteran issues. I have some absolutely phenomenal, informative guest speakers. Commissioner Sadi was one of the guest speakers. Manny Meneses is a guest speaker many times at the coffee houses. There needs to be a way to have, I was introduced to the coffee houses by a inventory of all the veterans that have their DD-214s on file in the location of that municipality. Then a mailer was sent out inviting all veterans to a coffee house for chit chat and get together and talk about veteran issues. It saddens me greatly to see veterans, World War II, waiting 70 years to hear about the benefits, and in most cases, I'm too late. There needs to be an upgrade with the Connecticut Veterans Affairs mobile app, CT Veterans. That is one of the most impressive working tools you can have on your phone, discussing with veterans all the issues, both federal and state, and also the crisis assistance for PTSD or suicide prevention. There's got to be updates made either manually or internet, working with the different veterans organizations and groups and setting up a distribution tree that when the information comes to the VA or other nonprofit organizations, it can be distributed to each local veteran representative and then into his area, municipality, all the veterans organizations to pass the word about changes, updates, upcoming events, and points of contact available to all veterans on any issue that they might have. And I would also like to see the annual training continue and be upgraded with the Veterans Affairs, that not only does it include all the latest changes, but it has a point of contact for the local veterans, representatives in all areas. I have worked with other veterans that are not in my area, and if I could refer to them to somebody more local and have the local veterans organizations offer help or assistance or guidance, it would make the whole system a lot more efficient.
Mr. Burridge, your 3 minutes are up. If you could please summarize.
Summarize, we need to have more communications and being able to reach the veterans so that they are aware of the benefits and how they can use them.
Thank you. Thank you, Mr. Burge.
Thank you. I appreciate that. Thank you.
Any questions, Mr. Burge? Representative Ferraro, I see your hand up. Please proceed, sir.
Thank you, Mr. Chair. And I'd like to thank the gentleman for his testimony. Certainly to everyone here, it's pretty obvious that his level of frustration. I just wanted to impart to him that his frustration regarding the level of communication to veterans is shared by probably every member of this committee. We work hard here to try to improve the quality of life for our veterans in Connecticut. And each session, we successfully put on into statutes new laws that would enable veterans to receive more benefits and be have available to them resources. And it's very frustrating that with the speed of the new statutes that come on board, the communication back to the veteran that those new benefits are available is sometimes, and most times, not really adequate and not timely. I know that back a few years back, I was successful in getting the bill for handicap placards put through for veterans with PTSD. And that was years ago. And even today, I talk to some veterans if they know about it, and I find out that they don't even know that that benefit exists. So I did hear in his testimony that he spoke regarding being able to mail the veterans under his purview and make them aware of the coffee houses. And I would guess that all the veteran representatives around the state have similar mailing lists. If those mailing lists can be merged, and a monthly circular can go out through this merged mailing, I think it would go a long way to helping the veterans have timely information. With that, my question back to the gentleman who testified would be, does he think that that's true, number one? And number two, does he see it as logistically possible to merge the mailing list of all the representatives in Connecticut? Through you, Mr. Chair.
Thank you, sir. I greatly appreciate that. And yes, filing your DD 214 in your state local town hall makes veterans eligible for a tax exemption, property tax exemption. That is your first form of all the veterans that are living in the area. Yes, you can condense somewhere with a one-point contact of all the veterans listed that have their DD 214s on file in the state. To get it out to the local representatives, then you can use your distribution tree to get it to the representatives, to the organizations that serve veterans in that area, and then other major concerning veterans that have other mailings through email and Facebook and other social medias to get the word out. You've got to have a local point like the Veterans Affairs to conduct all that and give them the permission to collect all the personal data from the DD 214s listed at Town Hall. But that is how I got interested in serving veterans, was by receiving a mailer from my name listed in the DD 214 Town Hall records.
Thank you.
Thank you,
other
Mr. Chair. Thank you, Mr. Chair, and I thank the gentleman for his answers.
Thank you, Representative. Any other questions for Mr. Burge? Seeing none, Mr. Burge, thank you so much for your time and testimony today.
Thank you. I appreciate that. Thank you for hearing me.
Have a good day.
You
Up
too.
next, I have Mr. Eric Hammerling. Mr. Hammerling, how are you?
It's great to see you. To all the honorable members of the Veterans Affairs Committee, my name is Eric Hammerling. I'm the Executive Director of the Connecticut Forest and Park Association. I'm also the son of a veteran and grandson of 2 veterans, and respect the important work that you do on this committee. I'm testifying today in opposition to SB 336, an act exempting veterans from the passport to the parks fee. This bill would result in a direct cut to funding available to operate and maintain Connecticut's state parks. Not only are state parks a cornerstone of Connecticut's outdoor recreation economy that generated $3.3 billion in 2020 and supported over 41,000 jobs, but also getting outdoors in state parks offers a wide range of physical health, mental health, and social engagement benefits to veterans and everyone. Every year since the Passport to the Parks began in 2018, more people have been getting to state parks every year, and park attendance in 2021 was about 13 million visitors. Because of inflation, rising fuel prices, and other increases in the cost of doing business, it is getting more expensive to operate and maintain state parks with a workforce that has remained flat for the last few years. To cut state park funding now, when operations and maintenance needs are greater than ever, would be devastating. The Passport to the Parks fee of $5 per vehicle per year is reasonable, especially considering that before the passport went into effect, just one weekend visit to a shoreline state park would cost any Connecticut resident $13. When the cost of everything else has risen, this $5 fee has not increased since inception. And as you know, all members of Connecticut's public are able to get into state parks for free, thanks to the passport. We ask you to remember that before the Passport to the Parks created a reliable level source of support, state parks and campgrounds were on the brink of collapse. The Passport to the Parks went into effect in 2018 because in the previous year, 4 campgrounds were closed, and both services and operating hours at state parks were curtailed. Backsliding to when state parks and campgrounds were in crisis and threatened with closures would be unacceptable. We are not opposed to SB 336 because it is exemption for veterans. The current Passport to the Parks fee is fair because it applies equally to every vehicle owner. Exempting veterans or any group from paying this fee would open the floodgates for other groups to request an exemption, and the critical revenues generated by the Passport would quickly be whittled away. Please oppose SB 336 and keep the Passport to the Parks intact to help ensure Connecticut remains a special place for veterans and all people to live, work, and play today and far into the future. Thank you for the opportunity to testify, and I'd be glad to respond to any questions you may have.
Thank you, Mr. Hammerling, for your testimony. Any questions? All right, seeing none, thank you, Mr. Hammerling, for your testimony today. We appreciate it.
Thank you.
All right, I see Representative Wheelander has entered the room, so I'll have her go to Representative. Are you there? Representative Wheelander?
I think we've seen a direct.
Good morning. All right, we'll come back to her if she pops back in. I don't see Senator Kelly in the room yet. He's on our list, so we'll go to Mr. Kennedy. Mr. Kennedy, good morning.
Good morning, Senator.
Please proceed.
All right, thank you. I'm an Iraq veteran, the Connecticut team leader of Iraq and Afghanistan Veterans of America. I'm actually kind of surprised to be here in this position, and some of you may be as well, but I'm here in opposition to SB 340 as it's written. We do have recommendations for how the bill could be improved so that we could support it. We take this issue incredibly seriously. IAVA Connecticut was the lead advocate spearheading the passage of PA 18-47, which extended state benefits to veterans with undeniable discharges and certain mental health conditions in the first place. We were also vocal supporters of the creation of the EQRB last session, and we're dedicated to ensuring that there are no unnecessary barriers between our state's veterans and any vitally necessary benefits and supports that they can receive. So currently, veterans receive these benefits with a simple form. So to me, it seems the benefit of this bill would be that it seems to allow a diagnosis from a private provider to receive benefits in addition to a VA provider as currently provided. And we would wholeheartedly support that idea. But currently, the EQRB procedures put some significant requirements on applicants that aren't required for those with a VA diagnosis, who only need a simple form from their doctor saying that they were diagnosed or they disclosed military sexual trauma. The commissioner characterized this requirement as for a diagnosis to show that the condition was more likely than not the reason for the discharge, but this actually appears nowhere in the current statute. Right now, all that's required is a diagnosis or disclosure. And that was a very deliberate decision on the part of the committee and the advocates for the bill in 2018. For the conditions most directly connected to military service, we applied a presumption in favor of the veteran. And there are two purposes for this decision. One was to reduce the time it took to receive the benefits in contrast to the federal process. And two was to avoid re-traumatizing veterans by unnecessarily forcing them to recount their trauma to a board when they had already done so to their doctor or other provider. I would point out also that this is becoming the preferred method of providing these benefits in other states. New Jersey is getting ready to pass a bill modeled explicitly on Connecticut's. At a recent roundtable about that bill, even the New York advocates who proposed this board system agreed that ours was the better approach. So I certainly respect the commissioner's opinion on this, but I can see how this proposed change would make it easier for the DVA. I can't see how going through a board would be a simpler process for the veteran than simply having a provider fill out a form. I've submitted pretty lengthy written testimony, so I'll cut straight to our recommendations. If the committee wishes to allow veterans to receive benefits with a private diagnosis, it should do so. This has been an impediment to some veterans, and expanding our options would be a welcome change, but we don't see a reason why this would have to go through the EQRB rather than the current process laid out by PA 18-47, which requires, again, only that the clinician fill out a form. And I think if the committee wants to take advantage of the EQRB, which can handle more complex cases, it should do so with things that aren't covered by 18-47.
Mr. Kennedy, your 3 minutes are up. If you could please summarize.
Sure. So our final recommendation is that I didn't include this in my written testimony, so say it quickly. This form is written by the commissioner, by the DVA. If they have concerns with any disclosures in that form, they should change it themselves. So finally, we definitely support the idea behind this bill and this board, but the bill as written, we have to oppose. Thank you.
Thank you, Mr. Kennedy. Representative Boyd, you have a question?
Thank you, Senator. Steve, thank you again for all of your advocacy on this and a number of other issues as well. We really do appreciate it. We count on it in a lot of ways. I guess I'm just trying to reconcile a little bit, having read your testimony and conversations, and also having extensive conversations with the agency as well. How do we harness the resources that standing up the board like we did last year does? Because there is a tremendous amount of resources. And I think, as you mentioned, there is a certain amount of complexity here. But certainly, I don't think any of the intent of, and I'll assume the agency is not looking to this, and certainly this committee's not, is by making the process more cumbersome for those to get benefits and services that they frankly earn. So I guess we're trying to, how do we reconcile those two things and harness the best parts, but not deny anybody any access?
Yeah, absolutely. I think that having this board in place could be tremendously helpful. I think that the way to do that, though, is to leave, I think we've covered veterans with PTSD, veterans with TBI, and who experienced military sexual trauma pretty well with the current bill. That's a very simple system. I do think that if there are concerns about what the form is, that can be changed. That's not written into the statute. The DVA can change that themselves. But if we do really want to harness the EQRB, they're in the same way that this was passed to cover things like sexual orientation, gender identity. That's not going to show up in your DD 214. It takes a little bit more fact finding to figure that out. I think you could do the same thing with mental health if you're going to expand the conditions that are covered. So if you want to have the board take a look at things like major depressive disorder, just more generalized anxiety disorders, something like schizophrenia that was aggravated by service. There are things like that could have an impact on your discharge that when we passed this bill in 2018, we weren't comfortable drawing that connection as explicitly and making a presumption that it was connected in the same way that we did with the trauma-related conditions. And I think that you could absolutely use the EQRB to look at those things and have someone have to make more of a case and present more evidence to show the connection rather than making that presumption. I think that would be a really good use of the EQRB.
Would you support a two-pronged system so that somebody who's looking to get their status changed could go the traditional route that is currently in statute, or opt to go through the board route? Is there kind of a choose your path on the individual, or is that not a good idea in your estimate?
I mean, I don't think we would, as long as the other option is still open, I don't think that there would be harm in making it possible. I don't really see the use of it. I don't know why you would go through, because especially when you look at, I mean, the board is already soliciting these applications anyway. And when you look at the requirements there, it's significantly more and would be more time consuming than just getting this form. So it's hard for me to see why somebody would do that. But I mean, if you wanted to open it, I think that's fine. It's just, I think I would be a little bit concerned that, not that that's the plan now, but once we're doing that and there are more requirements there, it's like, well, why do we have these two systems? Let's just consolidate this all under the board, which is how it currently works in New York. And then that would actually be basically stripping away this much simpler path that veterans, currently have a right to.
All right, very good. Again, appreciate your insight and advocacy. Thank you, Senator.
Thank you, Representative. Any other questions for Mr. Kennedy? Let's see. No. Thank you, Mr. Kennedy, for your testimony today.
Thank you.
Okay, up next, we have Representative Wielander. Representative, floor is yours.
Thank you. Good morning, honorable committee co-chairs, vice chairs, ranking members, and all distinguished members of the Veterans Affairs Committee. Thank you for the opportunity to testify this morning. My name is Mary Wielander, and I am here in very strong support of SB 343, an act concerning military occupational specialty working group and a grant program for the reimbursement of certain licensing, certification, registration, or tuition fees. Currently, we are seeing the need for skilled tradespeople across every sector of our economy. Simultaneously, we often have members of our armed forces re-entering civilian life where the skills and expertise gained during their time of service are not able to be officially or professionally recognized. It was with this in mind that I respectfully submitted this proposal to the committee in hopes that we could provide even a small amount of assistance and recognition to those who have already given so much. I'm incredibly pleased and grateful that the committee leadership recognized the potential of this proposal and are allowing for this to be discussed. Providing the opportunity for reimbursement for certain licensure fees and training or tuition costs may remove potential barriers to these career paths and allow for much needed positions to be filled and valuable members of our community to find options for personal success in the civilian sector, perhaps continuing in a field that they have worked in for years during their time in the military. I believe that this program will provide needed assistance and incentives to help support not only our veterans, but our small and large businesses across a vital industry for our state. As the sister of 3 combat veterans, one who is still serving today, I want to thank you for your work on this committee and your support of our veterans and their families. I would also like to extend my gratitude to all of our current and former members of our armed services and their families for their service and their sacrifices. Thank you again for your time today and for considering this proposal.
Thank you, Representative, for your testimony. Any questions for Representative Wieslander? All right, seeing none. Thank you, Representative, for your time and testimonies today.
Thank you, Senator.
Have a good day. Okay, we have up next is Mr. Christopher Arnold. Mr. Arnold, good morning.
Good morning, Senator Cabrera, Representative Boyd, honorable committee members. It's great to be back in front of the Veterans Affairs Committee this morning. As brevity is the soul of wit, I will endeavor not to repeat much of what my written testimony has said about the background on House Bill 5373, but I will speak to its necessity for the Department of Defense to protect our military children, hopefully in kitchen table English. I am Christopher Arnold, the Northeast Region Liaison at the United States Department of Defense State Liaison Office, operating under the direction of the Undersecretary of Defense for Personnel and Readiness. Congress has recognized that within the states, there are jurisdictional underlaps in areas of federal exclusive jurisdiction, such as military installations, where certain area offenses by juveniles leave victims with no recourse for justice and deny resources and treatment to the same at-risk populations normally served by state, juvenile, youth, and family court systems. The Deputy Secretary of Defense has directed the military departments to remove barriers to the proper investigation and adjudication of these juvenile matters. And the most straightforward way to remove these barriers involves the retrocession process, particularly in areas with juvenile presence, and this effort is now underway across the military. However, in federal enclaves where this process is not yet completed, has been declined, or is infeasible or impracticable due to mission requirements, the alternatives, which include referring juvenile cases directly to state courts, signing memoranda of agreement for the routine referral of juvenile cases, and seeking opinions from state attorneys general to validate juvenile referral practices, are all invalid means for the federal government to relinquish its jurisdiction without some type of state statutory authority. House Bill 5373 creates this vehicle to get us past these barriers. Enforceable law allows the department to relinquish jurisdiction when waived by the United States Attorney or the district court. As always, as liaison to the Northeast, I stand ready to answer whatever questions you may have.
Thank you, Mr. Arnold, for your testimony. I see Representative Boyd's hand is up. Please proceed, sir.
Thank you, Mr. Chairman. It's good to see you again. Thanks for testifying. We talked with Representative Conley a little bit earlier about some things. I guess from our point of view, it is your position or the DoD's position that the state of Connecticut would have to accept jurisdiction. It's not an automatic. Is that the reason for the statutory change, or does Connecticut statute currently prohibit any type of jurisdiction on federal installations? If you could just kind of walk through that piece a little bit.
Copy. So the portion of Title 10 in the United States Code that allows the department to relinquish its jurisdiction requires either a state to accept retrocession of the jurisdiction or have an alternative process in place to accept relinquishment of that jurisdiction. So from installation to installation, the conditions may vary. There's, gentlemen's agreements, memorandas of understanding, memorandas of agreement. It's sort of a a patchwork nationwide. And this has been an issue that has been formalized since Congress identified it as a requirement. The National Council of Juvenile and Family Court Judges National Resource Center on Military Connected Families and the Courts will assist municipalities and state courts with drafting and applying these memoranda pre and post retrocession or in lieu thereof. But you still need that state statute to accept the relinquishment when it is waived by the federal government. So the posture of the Department of Justice is essentially non-prosecutorial. They don't touch these things at all, which again could leave a victim without any recourse for justice, and it could, as Representative Conley identified, put at risk populations at further risk by not getting them the resources and treatment they need from the Connecticut court system. So some states perceive that they have this authority without the statute. The Deputy Secretary of Defense has identified the lack of statutory authority as a barrier.
All right, so that opinion is why a simple MOU would not be acceptable or not be as clean as an outright legislative change to accept it. I see. Would this, if Connecticut goes down this path, rather than just a responsive piece, this would give presumably the state police or other state law enforcement agency, or perhaps even municipal investigative authority, so if somebody went to a state court or state law enforcement to file charges or file a complaint and investigation continues, would there still be this barrier between access to the federal installation? Would this be followed by an MOU with an understanding? Is it an extreme situation might be the state police are investigating something and they're not given access to the facility because it's a federal installation. Is part of this change and then followed by an MOU, an understanding of how these normal proceedings would go. For example, if it was any other place within state jurisdiction, they can go to judge and get a warrant, right? So would a warrant be enforceable by the state of Connecticut on a federal installation?
So the short answer is yes, and there are already these types of memoranda in place prior to this effort. For example, Connecticut has a statute which was passed by this committee a few years back by my predecessor with respect to what the federally required agreement for child abuse and neglect proceedings must contain, such as identifying the military affiliation of victims or suspects, creating a reciprocal information sharing requirement between the military departments and the local authorities in Connecticut. So insofar as violations of state law, where these types of area offenses, not status offenses, are treated as civil proceedings, the federal appellate courts have generally perceived that state civil laws do apply within federal enclaves. Where they digress is with respect to criminal matters, and that is why this law is written to apply to violations of federal law within the enclave, because the Federal Juvenile Delinquency Act perceives these matters as criminal offenses. So now the DOJ, which already doesn't prosecute, could waive its jurisdiction and send it to the local system if that MOU is executed, and that's something that the municipality or the state feels is of value. They don't have to.
So the decision then, if there is a matter that occurs on the base, right, and it's the military police or the NCIS presumably that is a lead investigative, it would be their decision to involve local courts or to go a federal path?
Copy. So I didn't bring my handouts with me, but there's actually a wheel. It's like a wheel of acronyms, and it covers status offenses and area offenses, and it'll show you where the underlap is. So you're certainly right that certain matters would potentially be within the purview of the Naval Criminal Investigative Service. Others might be the Provost Marshal's office, the security forces that are at the gate. Those are probably three separate law enforcement type entities. Some of those would land on the plate of the Special Assistant United States Attorney. And that's what we're really talking about here, is the most serious offenses. So we're not looking to, have the New London police come in and pick up shoplifters at the PX. We're talking about, the Department of Defense being constitutionally prohibited from prosecuting individuals not subject to the Uniform Code of Military Justice, and for the appropriate adjudication of behavioral problems in juveniles on military installations. That's severely disadvantaged by our inability to leverage state and local resources. A review of the most serious types of offenses, such as problematic sexual behavior in children and youth, which I referenced in my written testimony, fortunately showed that Connecticut has not had a single one of these instances during the 4-year time period that was studied by the Department of Justice. So in that sense, this is a nice to have statute, but if a matter like this were to ever arise in the future, you would want to make sure that not only that victim's family received justice, but that offender, was dealt with, as opposed to, the non-prosecutorial posture.
All right, thank you. Yeah, and if you have that chart, I would be interested to take a look at what the various entities and law enforcement that are part of the military installation. If you could forward that would be great.
Copy. I know some attorneys in the Office of the General Counsel who would be really excited to hear someone likes their wheel chart, but for a lot it's pretty esoteric, Rep. Boyd, but I know you will be all over.
I'm a policy wonk at the end of the day. So thank you, Mr. Arnold, and thank you, Senator.
Thank you, Representative. Any other questions for Mr. Arnold? All right, seeing none. Thank you, Mr. Arnold, for your testimony today. I do not have anyone else on my list, so I believe that concludes our public hearing.
Yeah, there's no one else in the waiting room either.
Okay. Great. Anything else, Representative Boyd?
No, we are a model of efficiency. So thank you for your leadership, Senator.
Thank you all for joining us today, today's public hearing, and we'll see you at the next one. Have a great day.
Thank you. You too.
Bye-bye.
Bye.